Welcome to the law offices of Sabrina Lee. If you have ever been involved in a so-called pay-to-stay arrangement such as working with a company like Findream during your OPT period and have been hesitating to apply for a green card out of fear, this video may help you.
Sabrina is a certified immigration law specialist. Only 1% of attorneys in the US can earn this recognition. If you are in a similar situation, please call 213-375-8096 to schedule a consultation with us.
Our client had built a genuine, ongoing life with his U.S. citizen spouse in the United States. However, during his OPT period, he participated in a pay-to-stay arrangement through Findream, an issue that has drawn significant USCIS scrutiny in recent years. When he previously sought advice, he was told that his involvement could be viewed as willful misrepresentation under INA Section 212(a)(6)(c)(i). He was warned that he might be permanently inadmissible, that his case could be denied, or even that he could be placed in removal proceedings. Faced with those possibilities, he chose not to file. For 5 years, despite being eligible through marriage, he avoided applying for a green card because the perceived risk felt too great. It was only after reading about our firm's successful waiver cases that he began to believe there might still be a viable legal solution. By the time he came to our office, the fear and uncertainty had weighed on him for years. Rather than filing the I-485 alone and waiting for a request for evidence or notice of intent to deny, we recommended a proactive strategy: submit the complete marriage-based adjustment of status package together with a well-prepared I-601 waiver from the outset. This approach allowed us to control the narrative, demonstrate transparency, and present a comprehensive extreme hardship case up front rather than responding defensively later. After years of hesitation, moving forward required trust and courage. However, by handling the case strategically from day one and filing everything concurrently, we ensured that USCIS received a complete, organized, and well-supported record at the earliest stage of review. An I-601 waiver requires proving that denial would result in extreme hardship to a qualifying U.S. citizen spouse, a standard that goes beyond normal emotional difficulty. In this case, the hardship was substantial and well documented. The U.S. citizen spouse was managing ongoing health concerns while also facing emotional strain related to parenting and family stability. Their young child required attentive daily care, and the family relied on both spouses' financial contributions to maintain their household and future plans. Our waiver addressed the full scope of hardship: the impact of separation if the spouse remained in the United States, the difficulties of relocation abroad, and the combined medical, psychological, financial, and country condition factors involved. We also emphasized the positive discretionary factors, including the authenticity of the marriage and the family's strong ties. Each argument was strategically structured, legally grounded, and supported by credible documentation to meet the high evidentiary standard required for approval. USCIS scheduled an in-person adjustment of status interview at a Maryland field office in mid-2025 to review both the Form I-601 waiver of inadmissibility and the Form I-485 application together. Given the prior misrepresentation concern related to the OPT arrangement, careful interview preparation was essential. Our firm conducted detailed preparation sessions with the client and his spouse, reviewing the immigration history and preparing them to address the prior issue clearly and truthfully while demonstrating the bona fides of their marriage. Following the interview, USCIS continued its review, and by the end of 2025, both the I-601 waiver under INA Section 212(a)(6)(c)(i) and the I-485 adjustment of status application were approved. With inadmissibility formally waived and the marriage-based green card granted, our client finally obtained lawful permanent resident status after 5 years of uncertainty.
If you or someone you know has been affected by a similar situation, contact the law offices of Sabrina Lee at 213-375-8096 or email us at info@sabrinalee.law.
Our legal team will do everything in our power to handle your case. Your American dream, our commitment.